a series radiation medicine program. So far, we've heard about robots helping the elderly and patients with dementia in daily activities, and how the financial industries integrates artificial intelligence into their organization for quality and efficiency. We're delighted to welcome Professor Benjamin Alarie to give us a glimpse of how artificial intelligence is being used in the field of law. Professor Benjamin Alarie is the Osler Chair in Business Law at the University of Toronto. He completed his training MA and JD at University of Toronto and LLM at Yale. Before joining the Faculty of Law, he was a law clerk for Madame Justice Louise Arbour at the Supreme Court of Canada. Professor Alarie is a prolific writer, and his research is funded by prestigious sources such as the Social Sciences Humanities Research Council, the Canadian Foundation for Innovation, and the Ontario Ministry of Research and Innovation. His newest book is on the institutional dimensions of Supreme Court decision-making. Beyond his academic career, he is the co-founder and CEO of Bluejay Legal, a company creating next-generation legal research tools that harness the power of artificial intelligence to provide answers in tax and employment law, using machine learning to predict legal outcomes. Professor Alarie, welcome.
Thanks. Good morning, everyone. It's really a pleasure to be here. I've been looking forward to this ever since I got the invitation to come, because I've been really curious about what you folks would be interested in around predicting legal outcomes using machine learning and artificial intelligence. And so I've been running these mental simulations. What is this going to be like? What's going to happen in this room? And so now the moment has finally come. I get to discover what's actually going to happen this morning. But my plan is to start fairly broad and then drill down and explain in a very practical way, using a concrete example, how we're using AI to predict legal outcomes. So the idea is to really situate this, give you some broad scope perspective, and then drill down progressively into what we're actually doing. So that's the idea. I'm going to presume no legal sophistication of any kind necessarily, and no AI sophistication of any kind. So my aim is to make this as accessible as possible. Of course, if you have specific questions, you want to drill deeper, I'm happy to do that too. I also, at the end, want to explore the implications for the legal system and hear about what you think the implications might be for the healthcare system and your work. So I'm curious about that too. So I want to leave some time at the end for questions. And I understand that we're streaming this as well. So I'm also quite open to getting questions from beyond this room. So if you're somewhere remotely watching this and you want to ask questions, by all means, I hope we can figure out how to take those questions and get them answered for you. Okay. This, for a very long time, represented the state of legal technology. And you might say, oh, look, this is primitive, this is old, this is, a law library with conventional kind of stuffed leather chairs and lots of books, and this is how law gets done, and oh look, it's so primitive and quaint. And I think there are different ways of thinking about this. One is, isn't it amazing what the invention of movable type and the printing press actually wrought for the legal system? So prior to that, the state of the art had been handwritten scrolls. Lots of things just weren't written down. We had things like the Code of Hammurabi on, a big basalt slab, a stele. The book was actually a massive innovation, the Gutenberg's printing press, and it resulted in the proliferation of the recording of case judgments, the development of the common law, things like the Protestant Reformation, the French Revolution, all sorts of things coming out of the production of the book, and of course, the development of the modern nation state. So I attribute a lot of those things to the development of the book, and the book has been key to the development of the legal systems that we enjoy today. And the increasing complexity of the legal systems that we have today are a byproduct of being able to record information in books, warehouse them in places like this, in law libraries. There are great collections within a kilometer of here, one at the Osgood Hall Law Library at Queen Street, another one up at the Boer-Alaskan Law Library, just several hundred meters from here where I spend a lot of my time. These law libraries are actually amazing repositories of human experience and how we resolve disputes in society. And it's worked amazingly well. It's actually pretty cool how well the book has worked to facilitate the development of the law. And the way lawyers tend to think about law, and this is embodied in how we teach law at the law school, is a case-based method, right? So the idea is in the common law, we should be treating like cases alike and different cases perhaps potentially differently. So a lot of how we teach the law, and I tell this to my daughters are 13 and 6. Sometimes they travel with me on the weekends to the ROM, and we'll stop in at the law school, and I'll invite them to, and they're super excited to do this, go into one of the rooms at the law school and give a mock lecture. And they say, "Dad, what should we talk about?" I said, "Well, you can talk about whatever you want, but at the law school, mostly what we lecture about is whether something is an apple or an orange." Because are like cases alike? Are these things sufficiently similar to be treated the same? Or are they sufficiently different to be treated differently? It's really about identifying distinctions, making distinctions, arguing for distinctions. These books have been the grist for that mill for centuries now, and we continue to develop the law and draw finer and finer distinctions through judge-made law, through the common law. Okay, so what does all of this have to do with artificial intelligence and machine learning? You're probably wondering, what does this have to do with machine learning and artificial intelligence? Well, I think what it has to do with machine learning and artificial intelligence is things are starting to change. So this invention of the book was an amazing watershed for the development of legal systems. I think we're now seeing a similar watershed in the development of legal technology. And it started in the 1960s, 1970s with the introduction of digitization of the collections of places like this, right? So we started to see legal materials being digitized en masse, stored in online systems. And early on, very, very early on, they were text-based terminals. You could search them by keywords. They were slow. They had limited collections. It was expensive to digitize legal materials in the 1960s and the early 1970s. But eventually, by the time I made my way to law school, and I started law school in 1999, a lot of the materials had been digitized. And since that time, it's only accelerated. So where we are now is almost all of the legal materials that you would use to conduct research have been digitized in one way or another. And they're available through cloud-based resources, research tools. You can access them. You can do keyword searches. They're all hyperlinked. So you can find the stuff much more readily than you'd be able to in a conventional bricks and mortar law library. So that's exciting. That's a big move. Technologically, you can find anything, and you can be at remote locations and log in over the net. Boom, it's available in the cloud. Great change. So from another perspective, it doesn't represent that revolutionary of a change. Why? Because, well, we've taken, this book, so we've taken book materials, physical media, and moved it into a screen, so an LCD. So you can look at a screen and, or an LED and read it from a screen. But we're just talking about moving words from a paper-based medium to a screen. And so from that perspective, it's not actually that exciting. What I think is going to be the watershed change is now that we have all these materials available digitally, what can we do using machine learning and artificial intelligence to synthesize the contents of all of those materials? How do we leverage algorithms and computing power to transform that data into something actionable for lawyers? So this is where we actually introduce the big change in the legal system. It's going to have far-reaching implications for us. And so I hope to give you a flavor of that in the rest of the talk. Well, that's kind of where we are technologically. A lot of people are thinking about this in law schools, in the legal profession. Lawyers are very worried about the future of law, and they're worried about the future of the conventional model for providing legal services. The way I think about it is this is actually fantastic for lawyers because it's going to reduce the cost of accessing legal services, and it's going to increase the demand for a lawyer. So it actually means that the amount of value that lawyers can deliver per hour that they spend delivering legal services is going to increase, which means we're going to need more lawyers. We're going to be doing more justice. So this is actually a good thing from my perspective. Okay. So what is it that lawyers do when they give advice? This building, many of you may recognize this. This is the Supreme Court of Canada in Ottawa. One way of thinking about what lawyers do when they give legal advice is they're trying to predict what would happen if their client's situation, dispute, wound up before the 9 judges on the Supreme Court of Canada. What would those 9 judges say or hold or rule in that situation? And then everything else is kind of operating in the shadow cast by, what we expect as lawyers, the Supreme Court of Canada, to do in a given situation. So there's this backwards induction that you do right through to, you're sitting in your office as a lawyer doing an intake interview with the client, asking questions, collecting facts, really trying to understand the client's situation. And in your mind, you're thinking, okay, what are the leading precedents in this area? What do I know about the leading statutes that apply to the situation, the regulations? What other cases have I seen that are similar? And it's all filtered through the lens of what would the Supreme Court of Canada say if this were to go all the way to the Supreme Court of Canada? And by the way, essentially 0 cases make it to the Supreme Court of Canada, like as a rounding error, like it's 0.00001%, right? So virtually no cases make it all the way to the Supreme Court. I mean, it's not 0, it's really like 80 cases a year make it through to be judged by the Supreme Court of Canada, but it's a very thin slice of the potential cases that could be brought to the Supreme Court of Canada. Below the Supreme Court of Canada, I'm going to talk about a tax case today, so I'll just provide a little bit of context around how those actually make it to the Supreme Court. Any tax case that makes it all the way to the Supreme Court would have been heard first, immediately prior to the Supreme Court by the Federal Court of Appeal. And so there are 9 judges at the Supreme Court of Canada. There are 3 judges at the Federal Court of Appeal who sit on tax appeals. Those appeals will have been decided by the Tax Court of Canada. The Tax Court of Canada is a trial-level court. And at the Tax Court of Canada, you have 1 judge who hears the evidence, will hear witnesses, will have the arguments from both sides, and then will deliver judgment. Before it gets to the Tax Court of Canada, there would have been an administrative judgment made by the Canada Revenue Agency, often by the Canada Revenue Agency's appeals division. So inside the CRA, they have their own internal appeals division inside the Canada Revenue Agency. Before it got to there, it would have been dealt with by an auditor or someone who reassessed at the CRA that taxpayer's position. So imagine this from the taxpayer's perspective. You file a tax return, and you wait a long time, months, years, then you're reassessed. You challenge the reassessment. They confirm the reassessment. Then you challenge the confirmation of the reassessment. It goes to the appeals branch at the CRA. You could just pay it. Well, maybe this is y.000 whatever, actually make it all the way here. Then, it goes to the appeals division at the CRA. They either find in your favor as a taxpayer or they find against you. If they find against you, then you have the option to appeal to the Tax Court of Canada. Tax Court of Canada may find in your favor, may find against you. If they find against you, you appeal to the Federal Court of Appeal. And then maybe, if you still are losing, you can apply for leave to appeal. So the Supreme Court will not necessarily hear your appeal. They have to decide that it's of national importance before they'll hear it. So oftentimes, and this frustrates tax lawyers and tax academics, the Supreme Court says, well, this tax issue is just about money. It doesn't stand for a big animating legal principle, so we're not going to allow leave to appeal. So on average, there are maybe 2 tax cases heard a year by the Supreme Court of Canada. But in principle, what lawyers and law professors are trying to do is really understand, so how is the Supreme Court going to decide this case if this were to go all the way to the Supreme Court of Canada? So this is operating in the background, and it's how we basically socialize law students when they come to the law school. So we spend essentially 3 years of a student's legal education running through cases and trying to extract the principles from the cases. What principles are animating the judge's thinking in these cases? How do we think about this? And we play a lot of hypothetical games, thought experiments about, well, okay, on these facts, we know that the court decided in a particular way. What if we were to change the facts subtly? So what if we change one aspect of the fact pattern and we'll change it thusly? What do you think would happen? And, students will, present an opinion, and then we'll have a class discussion, and sometimes animated debate erupts in the class, and people feel strongly one way or the other. Usually what's driving those debates are conflicting legal principles. And so what we do is we basically pit all of these legal principles against each other, and they rub off against each other, and we kind of end up with kind of this clearer idea of what the different principles are that are animating the legal system. And students basically internalize it. When we're successful, students really internalize these legal principles, and then they are able to deploy them in new situations. Now, over the course of a 3-year legal education, students will read carefully, or at least be assigned to read carefully, 800 cases, 1,000 cases, something like that. And so the conceit of legal education, as it is currently delivered at, I would say, every North American law school, is that armed with 1,000 cases and struggling with those legal principles animating those 1,000 cases, you developed a fairly robust intuition for what the wonderful people at places like the Supreme Court of Canada will do when they decide a dispute that comes before them. So it's about developing that legal intuition. Okay. Now, thinking back to the prior slide and AI and machine learning, I think you're probably already starting to see what we can do, right? So we've got law libraries full of thousands and thousands and thousands of judgments from the courts. We have lawyers and law professors trying to predict what courts are going to do in new situations as they arise. The current state of legal pedagogy is to run through, 800, 1,000 cases delivered over, several years of legal education to try to develop that intuition, a heuristic, a feel for how judges are going to deploy these principles. What if we instead turn things around and say, okay, we've got all of this data, we've got computing power, we've got algorithms. What if we use those judgments as data to train machine learning algorithms? Maybe we can predict how courts will exercise their discretion in new cases by harnessing the power of technology. And that's what I think is going to be a watershed for the legal system in the coming decades. And in fact, it's already starting to happen. Okay, so there are different approaches that you could take to trying to predict how courts are going to exercise their discretion. Back in the 1960s, there was initial enthusiasm about computerization of law. Some people tried to develop expert systems, essentially elaborate decision trees, right, using computers. That one of the challenges that they had is that they're very, very fragile. So you can program a computer with a whole bunch of explicit rules about how things are going to work, but as soon as the legislature tweaks something or changes something, you have to redo the system. And there are ways to make it easier to manage and change, but those just weren't worth really the cost of maintaining them. Statisticians, econometricians have been interested in legal questions from time to time and have tried to use traditional, like ordinary least squares regression methods, for example, or maximum likelihood estimation, or various different kind of tools of the trade of econometricians and statisticians to predict legal outcomes. What these typically have had as a deficit is that you need to assume a certain functional form for estimating parameters in these kind of models. So if you're developing a model of how the law works, you need to kind of stipulate the way that relationship operates amongst a bunch of different independent variables, and then you can drive the dependent variable. The limitation there is really keen when you try to predict out of sample how well your model is working. And so with these traditional approaches, if you're lucky, you can get to 65% accuracy. Now remember, a coin is going to achieve 50% accuracy in legal outcomes. So moving from 50% to 65%, that's not trivial. That's an improvement over flipping a coin, but it's not that wonderful. Like, it's hard to say, don't worry, I've got this because I've got this model that is wrong only 1/3 of the time. That's not very comforting to a client, especially when that client is thinking about the prospect of having to pay for expensive legal representation if they're to challenge something in court. What we're focusing on is supervised learning. So we're using the data to kind of drive that functional relationship amongst the various variables. So we're using primarily judgments from the courts, and there are thousands of them, to basically figure out what the functional relationship is among all of these variables. And it's way more successful than the traditional approach. So on average, our success rate in predicting cases out of sample is around 90% at the moment. So 90% is, that suggests a 10% error rate, and 10% error rate is way better than a 35% error rate. So we're cutting down on errors by almost 3/4. In some legal issues, the error rate is as low as 6%. In others, it's a little bit higher. And part of that is down to judicial variability. So judges don't decide cases perfectly consistently. So part of the error there is, part of it's probably the error of the machine learning models. Probably part of the error is actually judicial error, I would argue. And it's hard to know what fraction is attributable to judicial error, or judges doing things that actually don't line up with the body of precedent writ large, versus a misspecification based on various data issues. And then unsupervised learning, this is really hard. This is probably where things will eventually go. In legal technology, we're nowhere close to that now, so we're at the cutting edge with supervised learning. Okay, this is really starting to pick up some speed, some momentum in research. This is a paper that appeared last summer, and folks are starting to take a close look at just what the social implications would be of using machine learning approaches to make better legal decisions. So this doesn't operate at the level of trying to predict how judges are going to make decisions. Instead, this research project just says, so what are the potential social welfare gains associated with using machine learning to achieve the outcomes that you might care about in the criminal justice system? So this is in the US, looking at determinations around bail. And the argument is, actually, so you can get the same level of crime, and you can reduce the number of people that you actually have to keep in custody. So you can keep the crime rate the same. If you care about just not increasing crime, you can keep the crime rate the same, reduce dramatically the number of people that you actually have in custody, or if you really want to reduce crime, you can dramatically reduce crime and keep the same number of people in custody. So there are errors being made there by judges and the way judges are exercising discretion. And it's not that surprising, because judges have about 90 seconds to make a bail determination. These courts are busy courts, right? And these judges are deciding on people's liberty interests very, very quickly, and they're making judgments based on thin slices of information. So no surprise, you can do better by harnessing big amounts of data and bringing that to bear on these kinds of questions. So lots of low-hanging fruit in the legal system. Bluejay Legal isn't the only company that's engaged in trying to actually predict court outcomes. So this is a company out of the UK that had a bit of a publicity stunt a little while ago, where they pitted their algorithm against a number of English lawyers, and they found that their algorithm trounced the English lawyers, who only got about 62% of the cases correct, whereas their algorithm got 87% of the cases correct. This is pretty consistent with how lawyers perform in my experience. So I speak a lot to groups of lawyers, often to, for example, a tax group at a law firm or a labor and employment group at a law firm, and usually it's a lunch and learn format, so we sit down, and I kind of do exactly what we're going to do together in a moment. So I describe a situation, and then we work through the client intake process, so the equivalent of a client intake process, ask a whole bunch of factual questions about that particular situation. Then before I click compute and get the prediction out of the system, I canvass the room and I say, okay, you're all experts in tax law or employment law, and it's not about embarrassing them. It's about actually just collecting, like just seeing how well calibrated they are to what the courts would likely do. And I say, okay, so you're all experts. What do you think would happen in this situation if it were to go to court and you actually litigated it out to an outcome? So we know the facts. These facts are incontrovertible. This is actually what happened. And a judge finds that these facts are true. How do you think that judge would map those facts onto a legal outcome? And we go around the room. And the junior lawyers are really nervous about this because they don't want to look dumb in front of the senior partners. And the senior partners are feeling a little bit, exposed because they're like, okay, well, I think I know, but, maybe I'm wrong. And we go around the room. And it's really interesting. I had an experience at a big law firm a few months ago where we did that exercise, and the first person to speak was the national managing partner of the group. And he said, well, 80% likely one way. And then went around the room, and most of the more junior lawyers in the room kind of followed, like, this is the easy thing that I'm just going to agree with the national managing partner. But then it got around to the head of tax litigation for this firm. And the head of tax litigation for this firm said, respectfully, I disagree. I think it would be 80% the other way. And then there are some other junior lawyers following the litigator who didn't know what to say. But at the end of this, it was interesting because there were a couple of different clusters of answers in the room. And I paused at that point. I said, okay, look at what's happened here. We all agree on the facts. We all agree on the facts. Your clients come to you and ask you for your professional opinion. They pay you a lot of money to deliver your professional opinion on their situations. And what I'm seeing is there's a ton of variance in the room here on the answer. This suggests to me that we have a very imperfect system for figuring out what the legal implications are of different fact situations. And so it was kind of the perfect setup for running through the analysis and showing them how this can actually work in practice, how they can use these machine learning tools to improve the advice that they give and improve their decision making. So it turns out, I'll tell you how it turned out. So I click compute, and boom, I think it said something like 86% likely that it'd go in the direction of what the tax litigator said. And so the litigator, it was interesting. So the litigator is much closer to the courts, right, and understands better how judges are thinking about things and spends a lot of time reading case law, trying to really understand the judicial mind and how judges are going to trade off different legal principles. The tax planners, like, this made sense after the fact to me, so I did a lot of thinking about this afterwards. The tax planners often don't actually interface directly with the court system, right? So they're engaged in this exercise of, what would the court say if this were to go all the way to the Supreme Court of Canada? What would the court say if this went all the way to the Supreme Court of Canada? And you can get yourself into a position where you start to see the law in a very client-friendly way when you're a tax planner, because you're not subject to the discipline of actually having to go to court and argue the situation. And clients are looking for favorable tax opinions. They want to hear, oh yeah, you don't have to pay that tax because, we've got this clever argument that we've put together. The litigator is kind of more hardened and knows, like, from the trenches, this isn't going to work. Like, we can't make this argument. And because so few cases actually go through the court, the tax planners don't face that discipline of the judges quite as much. And so it actually made sense to me as I rode back to the airport in my Uber. This is actually ecologically consistent in some way. So I found it very interesting. Okay, so we're using machine learning algorithms for characterization issues in tax law. There are tons of these areas. I'm not going to get into describing the technical aspects of this. This is really just to give a flavor of the different kinds of situations that can arise. So characterization of instruments as debt versus equity. So it turns out that interest payments are often deductible in tax law, but if you pay dividends, they're not deductible. So this is a big issue, and folks often want to characterize a certain investment as debt so that they can deduct the financing costs rather than equity. So this comes up all the time. Clever tax planners can come up with arrangements, transactions, series of transactions that result in really significant tax benefits. There's a rule in our income tax law called the general anti-avoidance rule that says, essentially, notwithstanding the fact that you may have come up with a very clever scheme for avoiding income tax, if it's too clever in the sense that it's a misuse or abuse of the legislation, if it's an unintended consequence of the legislation and the setup, you are not going to be able to enjoy those tax benefits. And so the real question is something abusive as a transaction? This is a very, very difficult question. And of course, tax lawyers, when they're coming up with a really clever scheme, have to say, and this may be subject to the GAR, they call it the GAR, the General Anti-Avoidance Rule, and then they'll have to give a GAR opinion, and then they say, well, in our learned opinion, the GAR would not apply to this transaction, or the GAR may apply, or the GAR should not apply, and they have code words that reveal kind of different levels of confidence. So they say the GAR may apply. They won't say the GAR will apply, because then they can't actually encourage the taxpayer to do the plan. But this comes up. This one is very common. Who's the primary beneficiary of an employer's expenditure? So this comes up when you're characterizing things as taxable benefits or not for an employee. So I don't know how things work at the hospital, but maybe you get free parking or maybe you get subsidized parking. There are a bunch of parking cases surrounding, are those parking spaces primarily for the benefit of the employee, or are they primarily for the benefit of the employer? And they tend to go different ways. So that's an example that we can address using our software, where a taxpayer has her center of vital interest. So this comes up a lot in determining residency for tax purposes. So there's this whole conflicting residence thing that gets resolved by treaty provisions. So Canada has a network of bilateral tax treaties, and one of the tie-breaking tests in those tax treaties is where a taxpayer has his or her center of vital interest. And so this is actually a really tricky question too. How do you know where someone's center of vital interest lie? And so you can use machine learning to figure this out. Do you have a question?
No.
Oh, okay. Yeah. Just don't want to leave you hanging in case I was...
Yeah.
Okay, great.
This isn't defined just by the residence in terms of the number of months that you spend in a particular country. It's not that simple, obviously.
Yeah, so it's complicated. We could get into it.
Okay.
But the quick answer is you can be resident in 2 different countries for their tax systems, and based on the rules in those jurisdictions, so in Canada and the US, each country, Canada and the US, has a rule that says if you spend 183 or more days in the country, you're deemed to be a resident for tax purposes there.
Right.
But you can also be a resident by virtue of just having lived in a place or having a residence in a place for a long time. So if you've lived in Canada a long time, then you move to the US and you spend 185 days in the US, Canada may not necessarily say, yeah, you become a non-resident of Canada for tax purposes, so you may have that kind of overhang, and you might still be deemed to be a resident in Canada, and you're also going to be deemed to be a resident in the United States.
Right.
The problem is, each country says you're presumptively taxable on your worldwide income. So if you have to pay half of your income as tax to Canada and half of your income as tax in the United States, the math isn't complicated, you're left with nothing. Right? So this actually doesn't really work, and that's why we have this bilateral tax treaty mechanism for relieving it. But the question is, so which jurisdiction do you have the greater connection to? And so you can use machine learning to figure that out based on how judges have determined this over time. Whether an expenditure on a building is current or capital. If you replace a roof on a commercial building, is that like repairs and maintenance, an ongoing kind of thing that you have to spend money on? Or is it a capital expenditure that you have to capitalize on the cost of the building and then only write off over time according to the capital cost allowance rules? There are tons of these examples.
So there's a lot of overlap then with accounting too, right? Because that current or capital operating, that's a constant accounting sort of movements, right?
Absolutely, yeah. And in a lot of ways, the tax system just maps onto accounting conventions, not perfectly, and also maps onto the general law around these things, right? Because there are legal tests for characterizing an instrument as debt or equity, for example. And so tax law is very resourceful in relying on other sources of authority for figuring out the world and drawing on conceptual lenses developed elsewhere. So you're right, so accounting is also relevant, for sure. Okay, one of the big things that challenges lawsuits, and I think this is a pretty accessible topic, is this question of independent contractor or employee. So when somebody's performing personal services for another party, the question often arises for tax purposes, is that worker performing services as an employee? So, essentially subject to payroll withholding, withholding at source, EI contributions, CPP contributions here in Canada, or an independent contractor, so carrying on business in his or her own name, and therefore able to take a number of deductions that would not be available to employees, not subject to withholding at source. And I think this is very common in hospitals, right? So you have a lot of doctors would characterize themselves as being independent contractors vis-a-vis the hospitals that they work in. So this is a really common thing. One thing that's amazing, I just grabbed this from the IRS's website, okay, I'm going to go back a little bit. So here's what the IRS says on their website: determining whether the individuals providing services are employees or independent contractors. Before you can determine how to treat payments you make for services, you must first know the business relationship that exists between you and the person performing the services. The person performing the services may be, and then they run through the different possibilities. The big ones are independent contractor or employee. And then they say, there are common law rules here. And it depends on the common law. The facts that provide evidence of the degree of control and independence fall into three categories. So they say there are all these behavioral indications, there are all these financial indications, and then there are indications relating to the type of relationship. And then they say businesses must weigh all of these factors when determining whether a worker is an employee or independent contractor. And they, in the final paragraph right at the bottom, they say the keys are to look at the entire relationship, consider the degree or extent of the right to direct and control, and finally to document each of the factors used in coming up with a determination. Okay, so they're saying it all depends on everything about the relationship, and it's a complicated legal test, and you should do it. And then they say if you don't do it correctly, it's really bad because you have to pay a whole bunch of tax. You're on the hook for a whole bunch of tax. But if you don't want to take that risk, what you can do is get a determination from us. But be aware that it can take at least 6 months to get a determination. It's a very weird way, by the way, of putting some guidance. Be aware that can take at least 6 months to get a determination. So is it 6 months? Or they're just saying, like, it's going to take a very, very long time. If I want to hire, so think about how absurd this is for a moment, right? I want to hire somebody today. I'm like, okay, so I want to hire you. Here's the agreement, the services agreement. What do I do? I want to hire them today. I don't want to wait 6 months. I have to fill out this form SS8 and then send it into the IRS. You can do the same thing with the CRA. It takes a long time. They don't provide good guidance. And usually when they do reply, it'll be like, well, you didn't provide us all the necessary information to make a proper consideration, make a proper determination. But based on the sketchy stuff you provided, and this is what we would say. And by the way, if anything changes at all in the relationship, then all bets are off. So this is totally impractical as a way to run the tax system. And then they talk a little bit about the misclassification. If you classify an employee as an independent contractor, you have no reasonable basis for doing so. you'll be held liable for employment taxes for the worker, and see this other code section for more information. So this is kind of frustrating. Okay, so now we get to how we're addressing this challenge using machine learning. So this is tax foresight. This is how individuals at big accounting firms, big law firms, smaller accounting firms, smaller law firms, and the federal government as well are analyzing these situations here in Canada. So we've trained this software on hundreds and hundreds of cases involving worker classification. This is just one function among dozens that we have in the software, but it makes for a nice example. The interface has to be easy to use. If you want lawyers to use technology, you say AI or machine learning to a lawyer and they go, I don't do that. You remember the library slide? I do that. I do books. I don't do machine learning or numbers or any of that stuff. Say, no, don't worry. You just have to see this. You can figure it out. It's going to play right into your strong hand. Like you'll be your forehand. This is good. So we'll run through an example, and I just grabbed a whole bunch of screenshots here. But this is literally what the software looks like. You'll see this is kind of like the client intake interview that I mentioned earlier. It's going to ask a whole bunch of questions around the control of the work, some background stuff about the ownership of the business and who's taking on the financial risks, the economic risks, and then how well integrated the worker is into the business of the employer, and it's going to give us a result. So we'll just take an example, a really simple example of a massage therapist who's providing massage therapy services at a spa. And we'll say that the spa owners say, you're an independent contractor, so they have paperwork. They say, you're an independent contractor, you're in business for yourself, to these RMTs who are providing therapy services. And these RMTs just sign. They say, okay, great. Does it matter? And the spa says, no, don't worry. This allows you to deduct a whole bunch of your expenses. This is good for you. You can provide services other places as well. Like if you want to, deliver massage therapy elsewhere, you can do it. You have your own clients. That's great. But you're going to come here and provide services consistent with the agreement. And let's just say the worker has been doing this for 12 months. So it's just collecting these background facts from us. And then we get into the control considerations. Is the worker monitored or supervised by the hirer? Yes, because they're providing all the services from the spa facilities. Who determines what work is to be done? Well, the spa kind of tees up the appointments. The worker comes, does the work, but they consult with the patient and say, what do you want? What's tight today? Do you want your hamstrings worked on? Do you want your back? What is it exactly? A neck massage? The worker typically in these scenarios doesn't set his or her hours and schedule. Like typically they're told, okay, you're working these days. There's some flexibility about arranging days off and those sorts of things, but typically it's dictated to them. Do they have the freedom to determine how the work should be done? Typically, yes. They're usually free to work for other people or companies. They can't delegate or subcontract the work. They can't just say, oh yeah, some other random RMT is showing up to do my shift. They cannot do that. And they typically don't have to wear a uniform. Okay, who owns the most important tools? Well, the hirer actually has, the facility in which these services are being delivered, and the massage table and all that stuff. So that it's the hirer who owns it. Who's bearing the risk? The worker's not really bearing any financial risk in these circumstances. So these are exactly the questions that judges would be asking and applying those legal tests, right? So the financial, behavioral, type of relationship kind of questions. These are the things that judges look to in deciding them. The worker's not reimbursed for work-related travel expenses. They do the work at the hirer's workplace. The hirers typically don't provide workers with training. Okay, now, this is the moment when I ask the room full of lawyers, so how do you think the courts would decide this? So just before I click compute, this is so what do you think, based on this situation? Do you think this worker is going to be characterized as an employee or an independent contractor? Now, this is grossly unfair to ask you all in this room what you think, so I'm not going to go around the room and ask you. But just for fun, just in your own mind, commit to an answer. So is it employee or independent contractor? And then, how confident are you in your answer? I mean, if you want to play...
So obvious?
Oh, I don't know. Okay, so... What's the obvious answer?
I thought it'd be independent contractor.
How confident are you? So obvious means like.
It's an employee.
Yeah. It's an
Oh
employee.
my goodness.
80%.
Employee 80%?
Employee 90%.
Speak for your current job.
I mean, this is so unfair because I bet very few of you have read any of these cases at all. So much of what you know about this distinction between employees and independent contractors has come from the thumbnail sketch that I provided of this. So if you get it wrong, I actually take a lot of responsibility because I'm responsible for your education on this question.
It's okay, these people are strong in their opinion.
What's your opinion?
I think it's an employee.
Okay, so let's see.
You mean you're responsible or liable?
Employee, 82%.
Really?
So what the system does is it's basically taken all those facts, compared them to all the previously decided cases. It's not a slam dunk. Like 82% is it's actually, that's 4 to 5. So 1 out of 5 might go the other way. And the system reveals how confident it is in that prediction. One of the things that you can do is very quickly do a sensitivity test so you can find out. So it suggests those few different things that tend to move the needle significantly in other cases. So sometimes as lawyers work through the analysis, they pause and they say, I'm not certain about this, how a judge would characterize the actual messy facts in the situation based on this question as it's being posed to me. And so you can run the sensitivity test and find out just how robust this prediction is around employee versus independent contractor. One thing that we learned early on in our testing is that lawyers are not just happy with that prediction. They want to know why, what's driving the results. So we developed a way of explaining or interpreting the predictions of the algorithm. So this takes a lawyer in behind the algorithm's kind of black box and says, okay, this is the reason why, these are the reasons why the algorithm's pointing in this direction. So it's kind of a plain language explanation. A lot of these explanations will actually cite to cases. So this one happens not to, but often they'll take you directly to a case. So there's a reference to a holding in one of the top cases, and boom, you click it, and it takes you out to the full text of the opinion so you can read more about it. The system also identifies the most similar cases from the existing body of case law. So in our early testing, lawyer said, well, I need to explain to me in words. I don't really do numbers. I'm like, okay, it's a very simple number. It's like 82%. Like, you must know what 82% means. They go, yeah, but I don't know if it's actually, if it's thinking like a magic 8-ball or something. Like, you just have this thing, and it's, you gotta show me that it's done some of the thinking, and then maybe I'll trust it. They said, what else would make us trust it? Well, if you can identify the leading cases or the cases that are most similar to my case, that'll give me additional comfort, because then I can go and drill down further and try to play this apple and oranges game and see, is my case really truly similar to this other case or not? And so when users hover over that similarity bar, it actually tells them exactly what the similar factors were from that case and the things that were actually different in that case. And so going back, you can see all those cases say employee. The 10 most similar cases all went in the direction of employee. So this is pretty strong, but it's not 100%, right? It's 82%, because there are things different about these cases. There's no case that's a precisely perfect match for the facts of this case that's been decided. But taking together the hundreds of cases that have been decided on this, the best prediction is that it would go in the employee direction.
So it looks like it was based on the definition of the hours, because when you go back to the text of the explanation for the 80%, it was the level of control, right, over the number of hours. By that definition, then all physicians in hospitals are employees then. Because we're all told.
It all depends.
Right?
So, no. Sorry, you're oversimplifying the test, right? Because you have to look at the entire relationship. It's very, it's one of those things, right? So we all crave certainty, right? We want a black and white answer. And it's really hard in these. That's why so many of these cases get litigated, because it appears obvious to the tax authorities that a worker is an employee, and it appears obvious to the worker that they're an independent contractor. And it's actually not at all obvious to others in the system, and that's why we need to harness all of this experience and wisdom from all of these examples to tighten the laces on the system to get better predictions.
So, like most Canadians, I have to admit, probably, that I know more about the American Supreme Court than the Canadian Supreme Court. And what little I do know, I know the way they choose the judges for this is not necessarily based on their objectivity, their body of knowledge. These are all really smart men and women who've demonstrated academic proficiency. They choose them based on their subjectivity. They choose them, the president and Congress and the Senate chooses them based on whether they're right wing or left wing, depending on who's in power, how they're going to rule on certain, they want to stack the court in their favor. So what that implies is there's a very large element of subjectivity to this decision-making process. And factoring in AI within that must be a big challenge. For example, in this case, say one of the questions was, does the employer provide the facilities? But say the massage therapist brings in his or her own table and sets it up. And then you suddenly get into a level of judgment that is perhaps not necessarily objective, but subjective. So how does that factor into this kind of a system? And where do you think that will play, how will that play out?
Yeah, so there's a very, very long answer to that.
Short answer.
Yeah, so the short answer...
80% likelihood.
No, the short answer to your question is you're exactly right on the way that the appointments process tends to work. It is more politicized in the United States than it is in Canada, and I've analyzed this a lot from an empirical perspective. So if you're interested in learning more, Andrew Green, a colleague at the law school, and I have a book just published last year by Oxford University Press looking at the different institutional design characteristics of different Supreme Courts, and we analyze at length the Supreme Court in the U.S. in Chapter 3, and we talk about the appointments process. So if you want to read more, I would direct you to that. But
I get a nice book.
Yeah, exactly. Don't worry. It's not exactly flying off the shelves. I have to do whatever I can to increase it. But the other aspect of this is, you're right. Judging is subjective. But what we take comfort in is in the level of predictability that you can get out of the system, right? So we are not factoring in things like the identity of the judges or the identity of counsel or the specific identity of the taxpayers in making these predictions. And so the premise of our legal system is that the rule of law applies to everyone. And so we're designing the system, architecting the system to be consistent with the best ideals of the legal system. We could increase our predictive abilities by saying, okay, tell me the judge, and then we could compare that particular judge's exercise of discretion against all the other past judgments by that judge, and have a little adjustment factor, and it would nudge it. Surprisingly, given the tenor of the debate around judicial appointments in the U.S. and the hand-wringing around what are the judges' political preferences and how are they going to decide on hot-button issues at the U.S. Supreme Court, actually it's something like 60% of the cases decided by the U.S. Supreme Court are unanimous. So they're not actually as politicized as the popular debate would suggest. So it's not like they always split 5-4 Republican and Democratic appointees. They actually, a lot of times, agree with each other, and there is a clear legal outcome that they all kind of agree on, and it's overdetermined. It's in those cases where there's a social policy judgment often and a constitutional question that gets people to split on the court. But even court watchers, law professors, there's been work done by a guy named Andrew Martin, who's a political scientist in the US, pitting algorithms and algorithmic predictions of what the US Supreme Court will do versus law professors and other expert commentators on the court. And the algorithms do better than the law professors. So the law professors think, oh, I know this judge is like pro this and this judge is pro that or anti this, anti that. And in law professor's imagination, it's going to go one way or the other way. The algorithms are better at predicting what the Supreme Court will do. So I think, So I think I take comfort in knowing that as cases are coming down, we're getting 90% of them right. So if that's true, and we're not building in, we're not accounting for those particular judicial subjectivities, that suggests to me that it's not as important. And that's in Canada. And our court is less politicized for sure than the U.S. Supreme Court, and we've done a lot of analysis of that. So, yeah.
So you're shown here to predict, like based on sort of predictable scenario, but the question would be, can the tool, probably tax is the example, is more objective, and probably that's why you chose tax-based, because it's a type of area that you can have, let's say, certain higher degree of objectivity. But how about if lawyers would use this to find out what's the tipping point element that they should use actually to get the opposite result of the prediction? Because they want to win the trial probably, but you could say, well, with all these objective factors, 80% this would be the outcome. It's based on the hours, let's say that was the element. But they can use it actually to say, okay, I have to find elements to use that as a tipping point to make the judge think that this is actually factual, self-employed or whatever. And with that, the question is, this is the dangerous element, but it can change the patterns of crime too, right? Because you could presume this could be used by people before building the case to build the case or do their actions in a way that they would know what would happen eventually if it goes ever to court and if it ever goes to things. So what do you think about the safety element of it?
Yeah, interesting question. So you're exactly right. I think, so the question, I don't know if everyone heard the question. The question, as I understand it, boils down to this. You can use this as a planning tool to figure out how to plan your affairs so as to get to be on the right side of the line for tax purposes, but also for criminal law purposes, for other purposes. So 2 quick stories. One, I got a question very similar to that by someone in government who said, Ben, this is really terrible because taxpayers are going to use this to plan to go right up to the line and then not step over the line. So this is going to be a tool used by people who are trying to avoid taxes. So this is going to be a really terrible outcome for the government. How are we going to collect taxes if people are using this to plan their affairs? And the response is, the response that I gave, I think it's the right response, is, you don't think people are already doing this? And moreover, you don't think people are coloring a little bit outside the lines when they're planning their affairs? Actually, this is probably going to rein them in a little bit rather than result in all kinds of additional tax avoidance. So that's kind of stage one, the humorous one. The second part is, actually, this is just a tool to contribute to legal certainty for both sides. So it means that you're not going after people who have actually complied and irritating taxpayers and kind of bullying people into making tax payments that they're not legally obligated to do. So it's a way of contributing certainty to the system. So that's kind of the first reaction on the tax point. On the criminal law point, again, I'd say the same thing. You don't think people are already doing this? I remember very distinctly telling my younger brother, so he was 11. It turns out, I don't know how I think I was 15 at the time. I'm like, Robbie, big news for you. When you turn 12, you're subject to the Criminal Code of Canada. So here's the thing. Like, if you are under 12, Robbie, you're under 12 right now, you cannot be convicted of a criminal offense in Canada. There's a blanket exemption for people under 12. So, as your big brother, it's incumbent upon me to tell you that now's your chance, bro. If you have in mind anything you want to do that's illegal, now's your chance. You have complete blanket immunity. I don't have any ideas for you. I'm just pointing this out. I wish someone had told me when I was 11. I must have learned it in my high school law class or something. Now's your chance. You have this, and the days are ticking by, so you got to act now. And because once you turn 12, then all bets are off. You know, the Young Offenders Act is going to apply. Like the consequence could be really draconian. But right now, you're presumed not to have the ability to form a criminal intent. So you might as well just go for it. So, I mean, it's a good thing I wasn't a lawyer, because you should not counsel people to do those sorts of things. But it occurred to me, that memory is prompted by your question. So I think we're out of time, because I heard some beeping. But thanks very much for your attention this morning.